Good morning. It's another beautiful day at Minick Law. Today we're going to talk about deferred prosecution agreements. And basically this is an agreement between a defendant that is charged with a crime and the state of North Carolina to dismiss the charge. Generally, a deferred prosecution agreement is going to require that the defendant complete certain tasks. Could include a requirement for community service. It could include a requirement to get an alcohol assessment or a drug assessment and complete recommended treatment. Typically, it's going to require that the defendant maintain employment or school, remain in school, and then it's always going to contain a condition that no further charges be received by the defendant during the deferment period. The deferred prosecution agreement is going to be for a specific period of time, and if at the end of that time period the defendant has completed everything that is required of them per the agreement, then the state will dismiss the charges levied against the defendant. Now, this agreement is going to look different depending on the county where the case is charged. For instance, some counties require that there is a written agreement based on a state form that is used for deferred prosecution agreements. Some counties have their own application process. Some counties go about it in a more informal way. They might just write something on the back of the folder containing the paperwork related to the case, and so they might just do it informally. But in sum and substance, a deferred prosecution agreement requires the defendant to do certain things in order for the state to agree to dismiss the charge. And again, applying for that is going to look different depending on the county where the charge is received, but the end outcome is the same with the charges being dismissed.